Good afternoon, good morning, good evening, everyone. And I would like to say that it is my absolute honor to introduce a panel organized by CPR's Y-ADR, Young Leaders in Alternative Dispute Resolution. Y-ADR is an incubator for the next generation of leaders in the ADR space. Our members include in-house and outside counsel specializing in disputes prevention and resolution, as well as a number of neutrals. We all hail from different jurisdictions around the globe. Our work focuses on developing collaborative and innovative approaches to building bridges, creating connections, and managing disputes. With that, let me introduce a member of Y-ADR who will be moderating today's panel. Lizzie Chan is an associate at 3 Crowns in London, and Lizzie is a powerhouse behind a number of Y-ADR initiatives. Lizzie?
Thank you so much, Juliana, for the very kind introduction, and also to Kai and other members of the CPR Institute. I'm a very proud member of the CPR Institute Young Leaders in Alternative Dispute Resolution. And outside of that, I'm a lawyer specializing in international arbitration at 3 Crowns. So as Juliana mentioned, the Y-ADR is an incubator for new ideas on ADR and other techniques that different companies are using to manage conflict to enable purpose. And what we try to do through the Y-ADR is to further the goals of the CPR Institute for the younger generation. And so today's webinar is a fantastic development opportunity for all of our participants, but especially our younger practitioners. We have a panel of 4 in-house counsel from a variety of industries, from social media and healthcare to energy and automobiles. They will share with us their advice on how to work effectively with in-house counsel. So why did we choose this topic? It's in recognition of the common experience that many junior and mid-level and some senior counsel experience, where they work really hard on a case, but they struggle to be visible to the client. It's also in recognition of the experience that many younger practitioners have, where they're asked to write commercially, to develop commercial acumen, but maybe are lacking some direction and some specific and concrete actions for what they can do to achieve that. And that can be especially difficult if, as external counsel, you might never have had the opportunity to do a client secondment or work for a client. Now, before I introduce our wonderful speakers, I would like to acknowledge our supporting organization, which is Young ICA. Young ICA is a leading arbitration knowledge network for young practitioners and students, functioning under the auspices of the International Council for Commercial Arbitration. Like the Y-ADR, we both seek to support our members to flourish in their international dispute resolution careers. I'm now very happy to introduce our distinguished speakers. In no particular order, because they're all wonderful. My first introduction is Dr. Hemma Lomax, who is a senior corporate counsel in the integrity and compliance team at Snap, which is a parent company of Snapchat. She is dual qualified as an attorney in the United States and as a barrister in the UK, and is currently based in Los Angeles. Prior to joining Snap, Hemma worked as a director and principal, counsel of global ethics and compliance at the Walt Disney Company. She has also served for 11 years investigating and prosecuting corporate fraud and corruption at the US Securities and Exchange Commission. She has a PhD in international human rights and humanitarian law, focused on conflict resolution and remedies under international law. Our second speaker is Megan Westerberg, who is an assistant general counsel at Eisai US, a global research and development-based pharmaceutical company with US headquarters in Woodcliff Lake, New Jersey. She manages the company's litigation and internal and external investigations portfolio. She also oversees information governance and provides support to Eisai's compliance and risk management functions. Prior to joining Eisai, Megan worked at King & Spalding, where her practice focused on complex litigation. Our third speaker is Daniel Huth, who is Legal Counsel, Global Litigation, Europe, Middle East, and North Africa. Daniel is currently a legal counsel at Shell's Global Litigation, Europe, Middle East, and North Africa team, and has been in this role since May 2017, joining from private practice. He's currently based in London. Daniel is responsible for advising on contentious matters and legal proceedings, including court litigation, arbitration, and mediation, arising across all of Shell's business syndicates in Europe, Middle East, and North Africa. Daniel is admitted to the German bar as an attorney and holds an LLM in oil and gas law from the University of Aberdeen. And last but not least, I'm pleased to introduce Brittany Mizarakis, who is Complex Litigation Counsel at General Motors, where she handles a variety of litigation matters for the company. Prior to joining General Motors, Brittany was a litigation associate at acumen, where she focused on complex litigation matters in federal court, with particular emphasis on class action, contract, and warranty cost recovery litigation in the automotive industry. Brittany was named a 2019 Michigan Super Lawyers Rising Star in class actions and mass torts defense. Before joining her firm, Brittany was a judicial law clerk at the U.S. District Court for the Eastern District of Michigan. Now, without further ado, I will proceed with our panel discussion. So in terms of structure, what we're going to do today is generally move through the life cycle of a dispute, beginning with effective pitching and moving through to hearing preparation. And then towards the end, we'll move to some general advice and tips on developing relationships with clients. This will be followed with a Q&A, and we strongly encourage active and enthusiastic participation from the audience. And then we will close with some final short takeaways from each of our panelists. So on to our first topic, which is about effective pitching. So I suppose this is the beginning of a dispute where you're trying to win work. And as we all know, there are many different ways in which work is won. Sometimes there's a formal request for proposal by a company. Other times the company might approach their trusted and long-term legal counsel for a request for a proposal. So, and oftentimes, younger practitioners might not be necessarily involved in this process, but might be interested in this process. So my question for all of the panelists is about their advice for effective pitches. And I'd love to begin to ask Daniel on your advice on that.
Thanks, Lizzie, and thanks for having me on the panel today. Can you hear me well?
Yes, perfectly.
Great. Well, I think in both of the scenarios that you mentioned, whether you approach a trusted counsel or have a full pitch with requests for proposals, I think there are 2 or 3 things I would focus on. The first is really if you show that you want the work that you're pitching for, and that includes a number of elements, like the motivation, of course, and also the preparation for the pitch, knowing the background and maybe giving away already some strategic advice, appreciating that this is a lot of work. And then the other element is necessarily the pricing around your pitch. And I encourage to, given that this is normally a competitive situation you're in, to make realistic assumptions, because the in-house counsel that's going to review the office will have an overview of different offers and will get a quite good feel for what are realistic assumptions, and may even have a pricing team advising on that. So in order to be successful in a pitch, realistic assumptions are necessary. Competitive pricing is necessary. Competitive fee arrangements, creative fee arrangements are necessary. But also, if you're successful in the pitch, to avoid later on struggle to renegotiate the fee arrangements, renegotiate the assumptions, it makes sense for both sides to really base your offer on realistic assumptions.
I think that's a really important point, and of course, it creates all these issues down the line if you blow the budget and you have to renegotiate the scope of the work with the client. Megan, I think you might have some thoughts on this question as well about effective pitches.
Sure, thanks, Lizzie. I agree with everything Daniel said. This one seems a little simple, but it's not. I'd say do your homework on the company, especially if it's new to you. The corporate structure. In our case, we're not publicly traded. A lot of firms come in kind of making those assumptions that we are, and they kind of angle their advice, and that's kind of a misplaced for us. Lizzie did a great job of pronouncing my company. It's not intuitive to a lot of people. So you could do your homework there. Our website gives you the phonetic spelling. So just coming in and having practiced the pronunciation of the company's name also might get you a leg up in the pitch process. And, I think for the more senior folks that are listening today, I do think it's helpful to have some junior folks around the table when we have those more formal pitch presentations. We don't always just want to see, the corner office folks. It's helpful to see who maybe day to day we might be interacting with more, and give a chance for those younger practitioners to have some visibility as well.
That's really great advice. And speaking of team composition, Brittany, I think you had some comments on this topic.
Yes, and thank you so much, Lizzie, for allowing me to participate on this panel. And just wanted to say good morning, good afternoon, and good evening to everyone. Thank you for coming. For me, when I'm getting a pitch or a proposal, I'm very interested. One of the first things I'm most interested in is who's going to be working on the case. And I like to see diversity in teams, and that's diversity, male female teams, also racial diversity, and I also like to see that there are younger associates that are put onto the team as well. And that's such an important piece because we're always looking to develop the next generation of lawyers who are going to work on our cases. And so we like to see lawyers who, are from, maybe newer, first, second, third year out of law school. So, we like to see diverse teams, and something I definitely look at, one of the first things I look at.
Thank you, Brittany. And Hemma, what are your thoughts on this topic?
Thanks, Lizzie. And just first, let me say thank you for the invitation. I'm so thrilled to be here. Look, I want to echo a lot of what's been said, but I encourage our audience to think of it as the interview that it is. You're interviewing for a job. It's a pitch, and to do the preparation, as has been said before. We will derive our confidence in you from you. So don't think of yourself as window dressing, even if you're a more junior attorney. There may be a rainmaker in the room, but we know that we're going to be working with you. And so I tend to look at it the same way I look at hiring. And there are 4 things I would recommend. Firstly, know what we do. Some people have made that point already. Know well what we do and who we are. Secondly, show us you have a passion for what we do and who we are. There's nothing wrong with a bit of flattery. We really appreciate that you are passionate about what we're doing every day. And that shows us a bit of depth in terms of not just you've read our website, but you actually are behind us in our purpose and our mission. Then we need to see the competence. We need to see that you've got either actual experience or transferable skills. So again, don't be afraid to show us that you can actually do what we need. And then my favorite is, on a bad day, you need to be the kind of person we want to work with. And while there may be rainmakers, there may be, we may have come to you because of your firm, practically speaking, we're going to be working with you as a human being. And so to the degree you can show that, again, we'll derive our confidence from you. In you, if you can show that you're competent, capable, and want to be there, I'm going to be feeling comfortable and trust that I can work with you. So those are my 4 things.
Can I throw in a question out there, which is, what's the difference you see, or like tips for, written pitches and oral pitches, and how often will you do in-person pitching where you'll have the team there? I have to confess myself that I've never actually participated in an in-person pitch. How often do you see that? What's really effective? And, are more junior members of the team being taken to these pitches? And please, the floor is open for anyone to answer that.
I think in the virtual environment right now, it's just all that much more easier. So I think, no one has to fly, no one has to travel to sit around a boardroom table. So everyone should really be trying to take advantage of that, because it's those interpersonal cues and interactions you can even get virtually. To Hemma's point, are you the kind of person we want to be working with day to day when times are tough? And that doesn't come to life off the paper. So if maybe you were asked for a written pitch, you could always consider saying, hey, I'm available to jump on a Zoom call if it would be helpful. And even if it's 15 minutes, you can bring yourself to life, and you can bring your experience to life in a little bit more of a persuasive and memorable way.
Thank you, Megan. Are there any other thoughts on this question?
I totally agree on the virtual benefits. I mean, look, it's possible if you're not supposed to speak in the pitch because your seniors are there, there's nothing wrong with a 5-minute meet and greet afterwards, so you can actually get to know the client. You don't have to bill for it. Just spend a bit of time with the client so you get to know them as a one-on-one. So there's lots of opportunities, I think, and the size of the screen is the same. So no one's judging who's the senior, who's the leader. We're just trying to get to know the team and how we can work together.
And I want to build on your point, Hemma, that you just made about, knowing the company and move into a question about dispute risk and prevention. I think, external counsel who maybe are focused on dispute resolution are really excited about actually proceeding to a dispute and moving into contentious matters. But based on an interview series that I've been fortunate to host, where I've been talking to 20 in-house counsel and companies all around the world, I've been disappointed to find that most of them don't actually want to go to arbitration. And of course, really big focus of what we do at the CPR is on dispute prevention. And we have a dispute prevention pledge where we invite companies and law firms to commit to taking concrete steps to avoid conflict. And we do that because, our motto is to manage conflict to enable purpose, because we want companies to get on with with their core business. So what are your thoughts, Hemma, on dispute prevention and risk mitigation?
Oh, I'm so glad you've asked that, Lizzie, because just to remind the audience, I'm actually in a compliance function. And so my whole job is looking at risk and looking at the ways we can mitigate risk and avoid conflict. And so just with that alone, let me just go back a step. We always say get to know the company, but it's very hard to figure out how to do that in any innovative way. So one tip I have for you is think about the lateral ways in which you can get to know the company and what we're thinking about. And risk is the highest priority for any company. They're going to be thinking about what could go wrong, and disputes are just one big symptom of that. So my recommendation is try to learn a little bit about how companies approach risk, what controls they try to put in place to avoid risk, how they mitigate risk, and how they remediate. If you can be aware of those principles and those concepts and dig a little deeper in that, you're going to have a much better opportunity to understand the company and where they are, especially if you're coming in at the time of conflict. Because even with conflict, you need resolution after conflict, and you need to go forward. And most of the time, we want to work with our business partners. We don't want just to stop and run. And so looking at holistically, how we can continue to work with our business partners and what controls, risk mitigation we can put in place is a really good idea for young lawyers to think about that, because you're going to come in there with a much broader view of what's happening and how to help us going forward.
I was wondering if any of our other speakers have views on dispute prevention and risk. And one thing I'm particularly interested is in this concept of risk, and whether, like, moving from private practice into the in-house counsel role, you've developed a different understanding, maybe a broader understanding of what risk is. Would anyone like to jump in?
Yeah, happy to chime in here, Lizzie, because I think there is, again, a number of elements to that, because I believe there are a variety of different types of risks involved, right? And having Hemma from her compliance function speaking ahead of me, I think compliance risk nowadays is a huge risk. But now that you specifically asked the distinction between in-house and external views, I think it is really seeing through the risk towards and focusing more on the commercial value behind the risks, right? And if you, in my view, if you really try to, in a commercial environment at least, prevent and mitigate risk, then it's always helpful for in-house counsel to get different views on the value behind things. And we have many conversations with our commercial representatives around that to really determine the true value in certain matters, in certain risks, to then try to find ways around it with our counterparties or alternatives. And I think that's a conversation, and it's something that we should always have. And if external counsel can, provide other views on that, alternative views, that's always very helpful.
I'm interested in following up on that point. Maybe Megan and Brittany want to jump in as well, which is, putting a value on risk when you speak with your commercial counterparts, do they want to put a dollar sign on what risk mitigation, conflict resolution looks like, or how does your commercial counterpart understand it, and what can lawyers do to like more effectively communicate with the business people? Anybody want to respond to that?
Sure. Just hearing the conversation, thinking about kind of the commercial lens, the in-house lens, the outside counsel lens. I think a big jump, or a big consideration for outside practitioners, when they're trying to learn about the company, the industry, our business, our risk tolerance, is to not make assumptions. And one of the things that was the most stark for me going from outside to in-house was I really mostly dealt with like-minded lawyers in companies. So I was an outside lawyer dealing with an inside lawyer, and that was my lens of the company. When I came in-house, my eyes were really opened to the sophistication of the business colleagues, what a title of vice president means or may not mean, the way they approach risk and compliance and other areas. And I think as an outside lawyer, you sometimes make those assumptions that everyone at the company is like-minded, like your in-house lawyer. But we are the same, we're trained the same way, we approach risk the same way. And so when you're giving advice to in-house lawyers, if we're seeking your advice or counseling on a risk issue or a kind of thorny initiative that may have some complex areas, it's really helpful for you to not make those assumptions that the company will be able to appropriately train to the issues, have the right guardrails in place, execute and monitor. We sometimes get this kind of powder puff response back, which is, yes, there's risk involved in that, but you can mitigate that. Make sure you have the right policies, the right training, and you're monitoring appropriately. And it's like, that's a big, big lift. So we'll baby step us through that a little bit more with your feedback. Other companies have tried it this way. Tease out what those, mitigating, risk compliance areas should be. Where should we be focused? It may be that it's too big of an ask. It's not worth that effort for the incremental business lift. So those are the trade-offs that we're focused on. And I know I was guilty of it. I think outside counsel assume that everyone in the company is, trained like a lawyer. So that's not the case.
I think you make a really good point, Megan, about the importance of challenging assumptions. And, in-house counsel have a perspective on the company, like a much broader perspective on the company and what it does compared to what external counsel have, where the lens is so often focused on the specific dispute itself. And I think your feasibility point is also really important. It sounds like external counsel need to communicate more with in-house counsel to understand the commercial realities of the business. So this nicely leads on to my next topic, which is this is where I'm going to start focusing us on the arbitration process and the outset of an arbitration matter, and what external and in-house counsel can do to really have a successful strategy at the outset. And one thing I'd like to mention here is also that the CPR started, I think, in 1977, and it was focused on that collaboration between internal counsel and external counsel. And when CPR was first founded, I understand that the focus was on how internal and external counsel can work together to reduce costs. Of course, the CPR Institute's ambit has become much broader than this, but a big emphasis of the CPR is on that collaboration. So at the outset of a dispute, perhaps when you're looking to launch an arbitration or to launch legal proceedings, what are your best tips and advice for how to work effectively with in-house counsel? And this can apply to issues like document collection, witness interviewing, building a strategy, etc. And I think, Daniel, I think you have some thoughts on this topic.
Sure, thanks, Lizzie. Yeah, I think from my point of view, it's really at the beginning of the matter is asking the right questions, right? So that's that's the role of the in-house counsel at the outset of a dispute, and any support from external counsel to figure out the right questions, to then continue determining, as you said, the right witnesses, the right documents to be collected, just getting on top of the facts, asking the right questions to then develop the case theory, the case strategy. That's really at the outset for me the most important thing to focus on.
And in practice, how do these strategy meetings work? Do they tend to be, you know, partner to senior in-house counsel, or do they tend to involve the whole team?
From my point of view, the broader the better, right? And that really also depends on the type of matter. The bigger a matter is, the broader you'd want the team to be set up, in order to ensure that you have the right mix of views at the table. And I mean, I say table now, probably nowadays it's going to be a call. But again, ordinarily it can be a workshop style in a meeting room or a call. So I think it really depends on the matter. But from my point of view, it's really a mix of views that helps to bottom out the right questions.
I think, Megan, you've already mentioned the land and checking assumptions. I was wondering if there was anything else you wanted to add.
Just quickly, it's very important for us at the outset of a dispute to understand the paths that it might take. So we're very much, you know, pinged from other stakeholders on, is it going to go this direction? How long will that take? What about this direction? How much will that cost? We may have insurance companies or parent companies or audit committees that we have to regularly update. So, you know, it's obviously an evolving landscape, any kind of dispute, but when we're going to be wanting upfront, you know, the outside counsel's advice and experience on what paths this dispute could take, and what are some of the big, you know, critical decision points along the way.
And Brittany, I think you have some views on this as well.
Yeah, well, you know, first, you know, Daniel's piece of advice is exactly right. You know, you rely on outside counsel to kind of ask the right questions and, you know, pass those questions over to in-house counsel to kind of help with that initial fact finding. And I think after that point, what I'm most interested in is, you know, what is your assessment of the case? What do you think our strengths and weaknesses are on each claim? What do you think? Where you think things are going? To Megan's point, you know, where do you think these are going to get dismissed, but these may stay? I think that discussion is what's really fruitful for in-house counsel, because, you know, depending on that assessment, you may need to begin to kind of give the business a realistic understanding of what may happen. And you need that collaboration with your outside counsel to be able to pass that advice along.
And Hemma, I think you have some comments on partnerships between in-house and external counsel.
Yeah, thanks, Lizzie. So yeah, of course, my advice is that it should be a full partnership from the outset, and really think about this as any other project. Don't rush the fact-finding investigation stage. To the points made earlier, don't make assumptions. Don't rush to give advice before you've actually made a project plan and thought to yourself, what could go wrong? What could change my advice? What do we not know that we need to find out? I always say our superpower is knowing what we don't know. And we really need your help to make sure we haven't made assumptions, that we think only this bucket of facts is relevant. But actually, you know, hopefully from your experience, that if there are another bucket of facts, that would change or pivot the advice. So a couple of, I guess the basics would be, don't rush when it comes to fact finding, making sure you understand the scope of the arrangement and where things are paths, as others have said, where things could go wrong or differently. Have a trackable, measurable plan. I think it's really important for us as in-house counsel to know the timelines and where we're going and what we need to do to help this along. And then, of course, a plan that's flexible enough to pivot when we do get new information that we didn't necessarily know. So I would say, finally, just equip me to be vigilant by asking, as we said, ask the right questions, ask coachable questions. Coach me to look for things that will impact your advice. So as an ongoing basis, it's not one and done. It's not you meet me, I tell you some facts, you give me some advice. It's obviously always a moving target, and I want a full partnership along that journey.
I think that's a really good point about, you know, that ongoing analysis, excuse me, about what you know and you don't know, and how the risk analysis might change. We're sorry not to have Carl Hennessy Airbus with us today, as he was going to be one of our he was going to be one of our panelists. And one of the points he said is that throughout a case, they're constantly thinking about opportunities to settle. And this can happen at various junctures in an arbitration. And Hemma, as you mentioned, what you know and you don't know. Of course, during as the case proceeds, you're going to learn more and more as the parties crystallize their claims and you get the facts and the evidence. So like there are always good points to discuss with the client about what changes. And Carl, I think if he was here, he would have mentioned the usefulness of mock arbitrations as well before the hearing to really test your arguments and also play the devil's advocate. And I know from my personal experience that using mock arbitration has really helped our clients to assess whether there are good settlement opportunities, not least because hearings can be very expensive. I'm just going to pivot to our next topic, which is how young practitioners can improve their visibility. And as I mentioned at the beginning of this webinar, junior and mid-level as a senior practitioners often work very hard on their cases and really know the facts, but they might not have that visibility with the client, partly because communication is often channeled through the senior members of the case. And so I was wondering, what is your advice for young practitioners on how they can increase their visibility of the client? And also, what is your advice for people who are, moving into that senior practitioner bracket and the ones that want to make partner? What can they do to, start to build their book of clients? And I feel like this is a particularly permanent issue in disputes because one, clients are often not hopefully, clients are not, repeatedly in litigation. The second thing is so often relationships are held by the firm rather than individuals. So any comments you have on increasing that visibility would be great. And perhaps I can start with Brittany.
Yeah, sure, Lizzie. To your first point about young practitioners and what they can do to increase their visibility, if they're working on a litigation matter, for me, for example, I'm always interested in working with young lawyers. I like I mentioned earlier, I really look for young lawyers to be on the team because I think it's important to get young lawyers in and start understanding, our cases and our business. And, the only way you can do that is by getting younger attorneys to work on the cases. So, I would suggest to really lean in and to take on a role and don't be afraid of in-house counsel. And so, younger practitioners they obviously are usually the ones who know the day-to-day of a case. And so I think that they're really best positioned to kind of give the client communication. So, they're great for reporting out, what happened at a hearing or providing the synopsis of, let's say we filed a brief and there's been a motion, or there's been an opposition. They can provide here's the opposition papers, and by the way, here's a summary of the points. And I think they can really be that day-to-day contact with in-house counsel. And I think for in-house counsel too can take something from this as well, which is that, make a concerted effort on your calls to say, and what do you think about this? Whoever the name is of the younger practitioner, and really give them some space and call out an opportunity for them to contribute to your team. And I think, it's good to have perspective of all different levels. It's great to have lawyers who have been doing this for a long time, but it's also great to have some fresh eyes on cases. And I think it's incumbent on us as in-house counsel to kind of break the ice sometimes and just say, and what do you think? So, I think that's one way to increase visibility for young practitioners.
Mm-hmm. And one advice that I got in interviewing an in-house legal counsel at Shell was to get a coffee with your in-house counsel. I can't believe I never even thought of that when I've been working. And Hemma, I think you have some comments on this topic as well.
Oh, Lizzie, I love this question, and I tend to come across a bit aggressive when I come to this question because I start wagging my finger a little bit, right? Because I think if you know what you want, you need to have a plan to get it. And so I'm going to say we need to be accountable and take ownership for our own visibility as individuals. I know there's a lot of people, it can take a village, but let's talk just for now about taking personal accountability and ownership of that. And what do I mean by that? I mean, ask yourself what visibility looks like and how badly you want it. Right? What does actually visualize visibility? What does it look like? What at the end of the year would you like to be able to say you did by way of getting visibility? And then ask yourself, what's stopping you? Right? What are your excuses for not getting that visibility this time? It could be other people, it could be you're not getting the support or the mentorship, but make that list, make that long list for things that are stopping you from getting that thing you've just said you wanted. Then think about what you'd like to say you've done, like literally, practically, what could you do but for those barriers? What would you like to do? And then use your initiative to create opportunities rather than consume. So if you remember nothing else today, remember this: create rather than consume. You don't need to wait for someone else to hand you a door to visibility or hand you that spotlight. There are hundreds of things you can do. And I know it's really frustrating for young lawyers to think, oh, I've got a network, I've got to have that coffee, but it feels uncomfortable. And so what I want to do is really encourage our audience to take the initiative to think about what they want and how to get there. And then if you look at examples of other people that seem to be successful in that area, you can emulate that. So look at resumes, look at CVs, look at LinkedIn and see what people are doing. I'll give you some concrete examples. I know we're going to spend time on this at the end, but let me just tell you, for example, you could be a Lizzie. You could be putting a panel like this together versus attending it. Right, so it's just a very simple example. You could join your diversity groups. You don't have to be of that specific diverse group to actually join and interact. So there's a number of ways that you can be seen and heard. Another way of visibility, we all know this, but I'm lazy about it too. You could publish. You don't have to actually write in journals these days. You can just repost on LinkedIn. I get a lot of visibility from piggybacking on other people's academic work, other people's notices, just to show that I'm passionate about the area. And if you're doing your job, what we've talked about a lot today, which is getting to know the business, you're not just doing it on Google. You're actually going out and benchmarking. If I want to know, for example, what might a company like Snap be thinking about, I might have friends at Facebook, Google, Microsoft. There may be people that can teach me what the industry is thinking about. And if not friends, there's a lot of industry groups that I can just sit and watch or participate in. So again, I get very powered up about this because I think once you open the door and unblock yourself, you'll realize that we're very fortunate. There are a lot of opportunities of visibility. And if you've got the energy and passion, you can get behind those now. Don't wait. It's never too early to do that. So yeah, I've got a lot to say, but let me just say that. Create, don't consume.
I absolutely love your point about being really thoughtful about how to raise your profile. And speaking of opportunities, I think, the online community has offered a lot of opportunities for young practitioners, and especially the very young practitioners as well. There are many very young arbitration groups now online. And I also really appreciated your point about how information is consumed now, and that maybe publishing a journal is very good, but then digest it maybe in a LinkedIn post for your audience. Now, speaking of effective communication, that's our next topic, which is how can you communicate effectively? I think one thing that can be frustrating for young lawyers is that they're told to write succinctly, they're told to think commercially, but how do they write something like a memo that is succinct but gets you all the points that you need? And can you tell us a little bit about what happens after you get a communication for external counsel? Do you digest it again before you send it to your commercial counterparts? Or in what form would you like communication so that it reduces your workload? I think, Brittany, you have some thoughts on this.
Yeah, sure. For me, again, I'm a litigator, so a lot of the communications I'm going to be getting from outside counsel are about probably the litigation. And I think one way to effectively communicate with in-house counsel, and this is one thing I always stress, and I think is really, really important. Everybody on this call, I'm sure, gets hundreds of emails a day, and and we are just trying to digest a lot of information in a short amount of time. And I think the outside counsel's role really is to make it easy for us to kind of absorb very quickly, like high level, what is the most important. So I think sometimes I often find outside counsel sending me something, maybe it's a brief and saying, see attached, and it's from the other side. And, you know, one thing that really needs to be done, and I suggest this for everybody, is when you send something like that to your in-house counsel, make sure that you're drawing out like the 3 to 5 most salient points from that brief, or, you know, what you think really I need to know about. Of course, I'm going to go and read it, but in the moment, you know, to have somebody who's already kind of synthesized and pulled out those high level points, I think is so important. And then the other thing I think that can happen a lot of times, obviously in litigation, there's many different ways things can go, and you're often, numerous strategic calls need to be made. And so sometimes you get emails that, here are some options, let us know what you think. And you know, when you're living the case day to day as outside counsel, we're really relying on outside counsel to make recommendations. So, you know, I always say to outside counsel, lay out all the options and make a recommendation and explain, you know, why you think that's the one, you know, that we should go with. And I know that may sound a little bit common sense, but I think that doing those two things can really help your in-house lawyer.
That can really help orient in-house counsel when they're making a decision. Megan, I think you might have thoughts on this topic too.
Yes, agree with everything Brittany said. Be succinct where that's required, and I guess start out with what is the form of the work product the in-house lawyer is looking for you for. Do we need the law school memo? Do we need the briefed cases? Are we looking for something to the point and quick that we can repurpose into, you know, slides that we have to turn around and present in the coming days? You know, I'm rarely asking for a legal brief. I'm looking for detailed bullet points. Those allow me to cut, paste, move around, shift, highlight, and digest. And I think also it's helpful too, in some cases, depending on the guidance, and this kind of gets back to our earlier point about know the company, know the industry, is, you know, where appropriate and where feasible, insert benchmarking and industry examples. You know, if you're counseling us on a certain idea or tactic or initiative or the risk around something, where have you seen it work? Where have you seen it not work? In some cases, depending on the client group and the in-house, the internal clients that we deal with, name dropping can be helpful and help them frame and understand what the potential issues are, or give them comfort that we're not going it alone, that we're not the first mover if we're uncomfortable being the first mover. So that can always help too, and you can do that in bullets.
Thank you, Megan. And Daniel, what's your advice on effective communication?
Yeah, I think Brittany and Megan already touched upon it. It is really know your audience, right? So the ultimate audience is not going to be the in-house counsel, but the commercial representatives that are going to take a decision on how to move forward. And in my experience, those are people that think in numbers and figures rather than legal arguments. So I'd echo, you know, there's sometimes no need for a full legal brief. You know, I'd make the exception because that enables us as in-house counsel to challenge and to figure out whether, you know, you've thought about all alternatives and allow us to challenge your thoughts in order to come up with the best possible work product. But in essence, I agree with what both Megan and Brittany have said. You know, we need concise advice that includes figures, that includes numbers, and that gives concrete advice on the prospects of success of different scenarios. And when I say that, I'm thinking about percentages, which sometimes feels uncomfortable, but I think between external and internal counsel, it is understood that those are estimations, but we need those in order to advise, to provide specific advice internally.
I think that risk assessment is really interesting, and more we're seeing companies actually use data and AI to provide predictive analytics. And Hemma, what are your thoughts on this topic?
Thanks. I'm going to probably layer on a lot, but again, this is super important because, again, why are we hiring you as external counsel? We probably could do it ourselves if we had enough time, right? And limited expertise and resources, but we're hiring you to help facilitate decision-making. We need you as a reason basis for making decisions. So that means you don't need to give us the answer, but you need to give us enough information for an advocacy piece. Others have said, we're often not the person making the decision. We're often having to deal with the commercial businesses, our seniors. Even if you work directly with the GC still has someone to report to. The CEO still has someone to report to. And so could I forward your communication to my GC? It's a good question. Or is there a lot of work I've got to do to make it digestible for them? So understanding the life cycle of decision-making at my company and how you are partnering with me along that life cycle, I think is critical. It's not just here's a job, dump it, I've done my job. It's comprehensive, I left no stone unturned. It's more, can I partner with you, Hemma, to make sure you can advocate? That means, for example, giving me a range of options, not just one answer, giving me a reasoned basis for that, those options, the pros and cons if necessary. Think about the questions that I'm going to be asked. So one's been brought up, benchmarking. What are the others doing in our industry? I'm always going to be asked that. And oftentimes I've got to go and do that work. If you've got that information from your client base or your industry groups, please let us know as much as you can. Also, the one question I'm always asked internally is, well, what do we do now? And why should we change it? And so if you don't know what we've done historically and why this new way is more important, because nobody wants change if they can avoid it. So I really do like the idea of being able to holistically advise my ultimate audience. So I think that's been said. Think of my ultimate audience and partner with me to get that advocacy piece.
Speaking of that partnership, I was wondering if you could comment on the degree of involvement that you might have in a particular case. Like, of course, that's going to differ depending on the value and the importance of the matter. It doesn't have to be a case; it could be an investigation or compliance matter. But how involved are you generally in your matters?
Yeah, I can talk to that. So let me say it varies, and I would never want to give an answer today because I don't want anyone to take away that that's the answer. It varies, and you mustn't assume. You must always ask, partner with me, and figure out. It depends on the case, obviously, and depends on my schedule and my preference in any one case. That said, because we need to be able to explain to our teams what is going on, as I just said, we're going to need to be very fully informed at any one time. I don't want to be saying to my team, oh, let me just get back to external counsel and ask them if I should know. So I need to be equipped. And the best way to do that, because things get complicated, there's thousands of communications that flow through, as you're all aware, is to have a tracker. Keep me organized on all the decisions I have to make, all the information I need to get to you, what's done with that information. And the best experiences I've had are when external counsel keeps me organized. They have a tracker. They remind me when we meet what's pending, what's to do, what's next, what's coming. And then that gives me a source where I don't have to call you every time to say, okay, here's where we are on these 5 issues. I say 5, sometimes it could be 50. So that's why it's really important. And so it's not so much how much I want to be involved. It's again, how can you partner with me to make me feel like I'm involved without having to do too much work?
That's really thoughtful about what external counsel can do to make your life easier. Now I want to move to a specific topic in international arbitration, which is about the putting together arbitrator shortlists. One of the issues that has recently become very important in international arbitration is how we can have more diverse appointments to arbitral tribunals. So I'm interested in your views about your expectations and inputs for external counsel when you're putting together these arbitrator lists. And in my, I'm sure Carl won't mind that I mentioned this. When we were talking in preparation for this panel, he said that, of course, external counsel often do the legwork first of putting together the arbitrator shortlist. And he suggested that maybe one of the reasons why many of the same candidates are often suggested is to have this conservatism on the part of external counsel, where they choose the people that they know well. And so then, what do you see as the expectations for external counsel? But then, what do you also see as your role as internal counsel in knowing new candidates and providing input on those shortlists? I think, Daniel, you had some thoughts on this topic.
Yes, indeed. So I think everything that you said is alludes to two different roles, right? What role does external counsel have, and what role does internal counsel have to trigger diversity? And maybe the first thing to start with is really to define what diversity means, right? And I like what Brittany said when we were talking about pitches and her interest in diverse teams. And I would echo that, because in my view, diversity means more than just one field of diversity. In the first place, it means not the same 10 old candidates, right? So anything in excess of that could cynically be already considered as diverse, but it's of course, it's gender diversity, but it's also, in my view, generational diversity, getting more younger practitioners on panels, and ethnic diversity of background, that different educations, different regions of the world, if we're talking about international arbitration. So I'd say it's a very broadly defined term. In order to get there, I think as external counsel, you simply have to think about it and ensure that your short list of proposed candidates covers those fields of diversity, right? That you've put in the thought, and if you don't have a diverse shortlist, explain why, and help us to challenge that. Help internal counsel to broaden that list, open that list up again. And it's, again, in the same vein, it's our responsibility to dare to appoint differently, which is sometimes not the easiest task, because if we're talking about higher values, then it's easier to justify a tested and well-known neutral rather than someone new we haven't heard about. So I think it's a challenge for all of us, and we have to tackle it together.
I'm really glad that you emphasize the importance of diversity and the role that internal counsel and external counsel can both play in that regard. And here I'd like to mention, some recent efforts in the arbitration space to promote diversity. One is Arbitrator Intelligence, which currently has a diversity campaign inviting anyone to submit questionnaires on diverse candidates. And the idea is that they provide a source that's publicly available that law firms can use to build the arbitrator shortlists. Another example is the new organization called Racial Equality for Arbitration Lawyers. So that seeks to promote more diverse candidates as well, looking at racial diversity in particular. But I entirely agree with you, Daniel, that we need to have a broad understanding of diversity. The next topic that I want to move on is actually built on what Daniel said earlier about the importance of facts and figures. So let's talk about costs and budgeting. And I see Alan Waxman is in our audience, and I had a wonderful interview with him where he told me that cost and budgeting is a golden opportunity to actually hone and think about the strategy that you want to take in your case. And I think, Megan, you had some thoughts on this topic.
Yes, it is a golden opportunity, and it's one of the easiest ways to get the outside lawyers on kind of our naughty list. I'm going, just in recent experience right now, I'm going through an experience with some firms where there's established billing guidelines, there's established, black and white, everyone signed up for them, and we still find month over month we have to kind of remind the law firms of some of those standards, and that takes a lot of time, and it just shouldn't be happening month over month. And it just creates a negative impression, and it's a lasting negative impression. So I guess the takeaway there is, if there's guidelines in place that are black and white, follow them, adhere to them, or have an upfront conversation of why you have to deviate from them. Don't let us find that out on the back end when we're reviewing invoices. It's none of us want to be accountants and sit there and line item, billing entries and all of that. So I would say that, and then also get out ahead of showstoppers and get out ahead of any showstoppers or big deviations in potential in the budget with, to Daniel's point, with facts and figures. So, this has emerged. We expect this to increase the budget by X or Y. And here's, how we can mitigate that, or we can phase it. If we need to phase it, this is what those phases look like. So anticipate those showstoppers, or at a minimum, react to them very quickly and go back to that budget we all agreed to months and months ago, and don't make us come to you to have you reevaluate it. Come to us with the reevaluation. That's tremendously helpful for us.
And speaking of showstoppers, a big showstopper is the hearing, which is a showstopper both for budgeting cost reasons, but also strategic reasons. And so what's your advice on hearing preparation again?
So, when thinking about this question, I think sometimes outside lawyers make assumptions that, as the hearing approaches, maybe they're uncomfortable asking for additional lawyers to the team. They think they need to stay flat on staffing. And we've had that burn us before, where when it's a little too late, the in-house lawyers start to realize that the outside team maybe got pulled in other directions, maybe had conflicting priorities, some things that took key team members away. We have to have that conversation, and you're doing no one any good by kind of hiding that. If a key core team member, as a hearing is approaching, gets pulled on another emergent matter for another client, that happens. So what are we going to do about it? Who's going to slot in? How are we going to adjust for that? Let's not be caught flat-footed, and let's not, and it's never a good look to have the in-house lawyers kind of figure that out on our own, and then try to fill the gaps. So as we're approaching, and we have a responsibility there too, but as that hearing is approaching and things are ramping up, a reassessment of who are the key team members, who's doing what, do we have the coverage we need, who's covering, what witnesses, what does that look like, and do we have enough warm bodies? What would it take to get us where we need to be? So just make those conversations intentional, and don't assume that we're expecting you to stay flat on people. Let's have a conversation.
I think Hemma, you had some thoughts on hearing prep as well.
Yes, I mean, I think we talked a lot about conflict avoidance and dispute resolution, but once you get to the hearing, things ramp up, right? You've got to get ready, you've got to get prepared. It's a big project, and to Megan's point, you can't stay flat in terms of staffing or energy on this. I think so. A really good plan is important, and I think one thing I've seen is, because the lawyers that have been working on it have been working on it for a while, they kind of assume that everyone in-house is up to speed. And oftentimes this is not the case at all. So there's various participants, people that you're going to need to pull in as part of the hearing preparation, and they just won't know the progress we've made. Don't assume that I have kept everyone internally up to date with the steps. So the intimate knowledge that you and I as external counsel, internal counsel might have is not shared within the firm, because everyone's got day jobs. But they're also very nervous to be part of this thing that's called a hearing, whether it's arbitration or not. I love what you said earlier, Lizzie, about mock arbitrations. I always go back to my time as a trial attorney in the UK, or even as an investigator for the SEC, where I always thought about what would happen at trial and then work my way backwards, right, in a due plan. I know that's a no-brainer, but that's what we've got to think about. Be strategic about what might happen at the hearing and how will you be prepared for every eventuality. Have you covered your bases? I like to think about the conclusions again. What would I like to hear the fact finder make? What conclusions would I like them to make, and how am I going to get them there? And then every step of the plan is a building block towards that. So a strategic plan, and Megan's so right, it has to be appropriately resourced.
And the final segment before we move to the audience Q&A is about building client relationships. And Rapport, I know we've touched on these topics a little already, but I'd like a more detailed discussion about very concrete steps that young practitioners can take. I think, Hemma, you had some thoughts on the topic of trust.
Yes. So it's going to be no surprise that trust is everything. I started by saying, we'll derive our confidence in you, but also we need to trust you all the way through. And certainly that's always on my mind. It's firstly, do I trust this person? Not just to be fun to work with on a bad day, but actually to have my back and to be competent and to be, again, a full partner in this experience. We didn't say this earlier, but about pitches, but remember, it's a thing for us to choose external counsel. We're probably going to be a lifetime relationship once we get you, because we don't want to keep changing for everything. And so we want sustainability and longevity with you. So I want you to think about that as well. Think of it as a long-term partnership, not just a case-by-case or issue-by-issue partnership. We're all busy. You've got other clients, we've got other issues, but when it comes to what we're dealing with together, we have to be in it for the long run. And one of the things you can do is, it's going to sound silly, but make me look good. I mean, quite frankly, that's what I need. It's not about looking good. It's about integrity, obviously, and doing the right thing. But in that point, help me do the right thing. Help me help my bosses, help my business, my commercial partners. And that could be things, obviously, we've talked about a lot of that, the way you communicate and what I can pass on. But it can also be the background support you give me. I don't have time to watch for developments on laws, but you might, because you're dealing with them with your other clients. You might have client advisories that you put together that you could just nudge me. I don't want to be spammed, but you can personalize that information for me and say, Hemma, keep your eye on this. Let us know if this impacts you. Because that makes me feel like you've got my back and you're thinking about me. Even if you're not thinking about me all the time, I kind of want to know that out there somewhere, someone cares about me and my work and my company. And so that to me is the best approach. Again, if you visualize that's how a partnership will be, you'll start doing things that make that real. Of course, there's the human touch, and people talk about, how we can have extracurricular coffees and happy hours, and I'm happy to do all of that. But if we're busy, you've got to be able to do that in the day-to-day. Like, we don't have to take time away from our families and time away in the evenings to dedicate a happy hour with me, if you can do that throughout our relationship.
I love your focus on the importance of the long-term relationship. And your comment reminded me of what the In-House Counsel told me in one of the Y-ADR interviews, which is the importance of horizon scanning and just reading about the industry, the relevant industry generally, so that you can foresee the types of disputes that might be brewing, and the types of risks that your client might be facing. I think, Daniel, you had some advice on developing client relationships.
Yeah, indeed. And 2 points. First, building on what Hemma just said, I think if you think about providing updates, more personalized updates, what I personally like to see is if a proposal or if an update shows me where to find value in considering something, right? If ideally it's commercial value, but there may be alternative values involved in thinking about something new. I think that's the first thing I would say, which I think helps to create that more personal client relationship. And then the other aspect I see is just start with your own networks, capitalize on the networks you've already established, because normally, and it is in one way it's a professional relationship, but it will always be a relationship of trust, as Hemma said, and that's a more personal relationship. And if you're building on your own network, you will have already established a personal relationship in the past, which will certainly help you to continue from there.
Thank you, Daniel. And Brittany, what are your thoughts on this topic?
Yeah, well, I first think that Hemma makes a great point. I mean, I always appreciate when people send me an article and say, hey, this is something that's, could be useful to one of your cases, or, have you seen this? Or some new, interesting legal development. And I always appreciate that. I remember that when people do that, because I know that they're thinking about me, and it's genuine. So I always appreciate when outside counsel does that. And to Daniel's point, using your existing network, we have at the company, we have many opportunities where we can collaborate with pro bono opportunities, or even service projects with our outside counsel. And that will be sent out to outside counsel, and anybody can participate if they're interested. And so there's some already ways that outside lawyers can use an existing framework and network and just participate. And I think that's a great way to just use what's already there and to meet other lawyers and to really put yourself out there. So you really, I think whatever you do, you have to be genuine. I think and be sincere and do something that you're interested in. But I know I've met other lawyers through pro bono projects that we've done together. And I think that's just such a genuine way to kind of meet one another and come together for good and helping a pro bono client.
I love that focus on being genuine and authentic self at work. And Megan, what are your thoughts on this topic?
Yeah, I think, Hemma mentioned spam. We get a lot of that all day, but and to Daniel's point, it would be great, something really practical I was thinking about young practitioners could do with the industry updates that your law firms put out, with the, breaking news alerts. We get those from the firm. It's coming from the firm. take it, especially if you're an author, forward it to me. Megan, I was thinking about the matter we worked on a year or so ago, happy to discuss it. I'll stop and read that, and I'll remember you. And to Hemma's point, it'll show me that you're invested in my industry and that you're kind of keeping us top of mind, which is great. And I think that's a great, memorable way. It doesn't require a happy hour or coffee or virtual happy hour. And then another thing that's a great opportunity, and then young practitioners can really shine here too, is, at least in the US, we have continuing legal education requirements and responsibilities that we have to meet a certain amount a year. We love it when our law firms reach out to us and say, hey, what are you facing right now? What are topics we as the law firm can put together for you and get you your CLE credit? But it's very tailored. It's not just, logging in to kind of meet the credits. It's very tailored to what we're going through. Or it's a significant matter that the law firm just came out of for a peer in industry with us that can kind of give us some insight to what's been reported publicly. So those are great opportunities. And as I think about them, we don't tend to see a lot of associates at those. And I think for the senior people who maybe are listening to this, bring the junior people to those. I'm sure they helped prepare the slides and did some of the research. Those are great opportunities for the more junior folks as well. So if you're a junior person, another practical opportunity would be to say to your senior folks, hey, what about this for CLE, a tailored CLE program? We could go to some of our clients and offer it. I'm happy to work on that with you. And we'll all, especially virtually, it's so easy now. The travel is a non-issue. And I know at least my team is always very happy to participate in those.
Thank you so much for all the wonderful advice. I just have one final topic that I want to cover before the Q&A, and that's on practical tips for developing commercial acumen. I think, Hemma, you've got some thoughts on this topic.
Yeah, so as I've already shown, I'm very excited about encouraging people to take ownership for this. I do feel bad when we tell people, get to know business, have some commercial acumen, because it's not something you can just go buy off the shelf. It does take a lot of initiative. It does take a lot of creativity. And so with that, I encourage you to be nosy and greedy. Be nosy, look at all avenues for learning as much as you can about how a business might think. It could be my company, could be my industry, it could be business more generally, but certainly the more I can see that you understand what my day job is and what issues I have to face, the better partner you're going to be. So again, the theme of partnership comes up. Again, how can you learn? So let's practical tips. How can you learn more about a company? I mean, Megan mentioned if it's a public company, you've got the filings. I used to work at the SEC. They're awful, they're big, but if you can just get used to looking at a 10K, an annual report, and in the US and other places it'll be the same, find those sections that tell you what we're doing, where we're going. It's gold. It's not that much to read if you can just get to that. The news, I mean, look, the tech sector's in the news every day. If you're paying attention, if you've got your head up, you can see what the issues are that are front and center for us. Hiring trends is another one. Get onto Glassdoor or get onto my website and see what we're hiring for. That will give you an instinct as to where we're growing, and where we're expanding, and what new areas we might be in. So in my specialization with anti-corruption, if we're growing globally, we might need to start focusing on rejigging our strategy for those certain areas and our risk thresholds and tolerance. Industry groups and professional organizations, we've talked about that a lot, whether it's, I don't want to assume, but sometimes we make the mistake as lawyers as only having friends and groups with lawyers. And we need to challenge that. Again, it's a question of networking, but why don't you think about the groups that you're not joining? What circles are you not in? Because you're not going to learn anything. And it can be as simple as following people on LinkedIn. Again, I do a lot of that. I see someone that I'm interested in, someone in an industry that's interesting to me. I just follow them. And then when I do get to the news feed, I start seeing things I never would have seen if I just stayed in my lawyer circle. And I guess the theme, when I say be a creator, not a consumer, I'm saying be entrepreneurial. And by that, I'm saying think about how we get things done, not how there are so many obstacles that you can't. So I know it's overwhelming to develop commercial acumen if that's not what you've been doing, but think entrepreneurially, think like a business, and say your mission is to learn as much as you can about X industry. You will be creative about how to do that. That's my challenge to you all.
I love it, and I'm going to take you up on your challenge, and I hope members of our audience do as well. I'm very happy to open the floor now to questions from anyone. Please feel free to just turn on your cameras and your mics. Are there any questions? Any questions? Oh, if not, I've got a question that Hemma, you and I talked about, what young practitioners can understand more broadly about the responsibilities of companies now. So, that's looking at environmental and social governance, corporate social responsibility, climate change, etc. What should we be noticing about companies?
Yeah, thank you for that question. So you may or may not have seen there's a lot in the press about environmental social governance issues when it comes to companies globally, a lot of global regulatory interest. And I picked this topic because it reminds me a little bit of what was said earlier about getting to know your company very well. And I think, Daniel, I think you mentioned the value creation in decision making, like what value does a decision make to a company? And it's no longer just in silos. It's no longer just in terms of dollar value. Reputation, brand reputation is everything. Investor interest is everything. And so as companies become more conscious and more aware of these things, whether it's their approach to diversity, their approach to climate change, their approach to forced labor in the supply chain, if these things are in any way impacted by the decisions you're advising on, bring that in. Think more holistically for your client as to what's on their mind. Because if I go to my general counsel or my CEO or my board with one single issue, they'll be grateful to me, but they're going to have to think about the broader implications and the downstream effects of that decision. And what might be legally sound, we might be banged to rights on the law, might be terrible for our reputation, or it might contradict something we said about our approach to an ESG factor in our filings or our reports. So I think it's really important to be aware of the types of ESG impacts and others that a company might have internally and externally, to not just shareholders but stakeholders, and then incorporate that into your advice so that you're giving me a range of options and a range of consequences as I make those decisions.
Daniel, Brittany, and Megan, I wondered if you have any thoughts about, understanding more broadly about the context in which companies operate, and maybe, are there areas of disputes that might not immediately spring to mind, and maybe in the context of like business and human rights, modern slavery, or other ideas? Is this something you might be able to comment on?
Yeah, maybe what I would add to what Hemma just said, and you touched upon that, Hemma, is that this is part of the overall risk profile nowadays, right? So if you advise on legal risk, you should necessarily know about the potential additional risks that a decision or a dispute may involve. So I think I echo what Hemma said. It's very important to know about it. It's very important to consider it, and as it's an evolving field, an evolving risk and evolving conversation, societal conversation, I think it's important to stay on top and to participate in that involving conversation, rather than stopping at having a certain knowledge, because it's certainly not there yet.
And Megan and Brittany, are there any particular issues in the automotive and pharmaceutical industry that you think young practitioners should be aware of?
Drug pricing, at least in our industry. So, that's obviously it's not so much in the vein of what we were just speaking about, but that couldn't be a more of the moment issue, at least in the United States. So all things related to access to medications and pricing of those medications, affordability.
And, in the automotive industry, anything in the logistics and supply chain, that's obviously something that's extremely important. I'm sure everybody has read about, chip shortages in the Wall Street Journal or wherever you get your news from. So yeah, in the automotive industry, I would say logistics and supply chain.
Thank you. So we have 5 more minutes. So I just want to invite any questions from the floor. If there are none, can I invite our speakers each to share their one final takeaway? Feel free to do it in any order you like.
I'll just repeat a couple of my gems. So be nosy and greedy, and be a creator, not just a consumer.
Thank you, Hemma.
Yeah, I'll jump in. You know, it's a partnership, and it's a long-term partnership between you and in-house counsel. So just, you know, remember that. And then I'll also just echo, you know, just be genuine and be sincere. And I think that will always serve you well.
Yeah, I would just say, you know, we love working with young practitioners. We know the value they're adding. So, you know, help yourself be heard. And if you're a senior person listening to this, we want to hear from your junior team members. We know they're behind the scenes doing a lot of the grunt work. We know that their mastery of the facts and the chronologies are unparalleled. So give them those opportunities, and you know, we very much value those contributions and want to hear from them.
Yeah, and I'll also repeat a few things I've said. I think help ask the right question, know what distinguishes you from, you know, from the internal legal team, help to ask the right questions, help to avoid surprises, dare to challenge, and make sure that, you know, there is no echo chamber going on internally, but that your challenges will help to improve the overall views.
Well, it remains for me to thank our speakers, Brittany, Hemma, Daniel, and Megan, for your time participating in this panel. But I also hope that we will have a long-term relationship, I and the CPR Institute, and thank you for taking your time to serve on the CPR Y-ADR steering committee. So thank you to Kai, Juliana, Jason, and all the other members of the CPR Y-ADR committee. And I'm very happy to pass the floor to Kai.
Thank you, Lizzie. This concludes our third panel today, and thank you everyone for speaking on this panel. Hemma, Brittany, Daniel, and Megan. It was a great panel, lots of takeaways here, and I'm glad we have such a great Y-ADR panel and such a great Y-ADR steering committee. For those of you who probably don't know, thank you so much, Lizzie, for staying up basically all night. People might not know, Lizzie is based in Hong Kong right now, and it is about, what, 2 a.m. now for you?
My pleasure to be here.
With that, it's just my pleasure to thank also the other two panels with Mark McNeil and Javier Samaniego on the European side. And I also want to thank our sponsors for this international conference. It's Borden Latner Gervais, Quinn Emanuel, and Tizini Freire, Advogados in Brazil. And also all of our CPR Global champions and our supporting organizations. They really make us have the outreach that we do and help us navigate the ADR world and help us implore ADR across the world. With that, I just want to let everyone know a little precursor for tomorrow. We will start at 11 a.m. Eastern and start with 2 panels on the Brazilian side. One will discuss dispute resolution under Brazil's new public procurement law. And the second one will discuss implications of ESG in dispute management. Then our last panel will be hosted by the CPR Canada Advisory Board, and we'll discuss suitable dispute resolution, pre-dispute or post-dispute causes. And with that, I want to welcome everyone for a networking reception. Just in a couple of seconds, I will open up some breakout rooms and hope that everybody can discuss a little bit about what we heard today and get to know each other a little more. Thank you.